both for the lovely introduction. Uh, Good evening, all present here. So I think the present speakers, they touched upon how IP is rethinking and making the people rethink about how we can transform IP. With AI, I think we are also into innovation, and it's more kind of innovating the IPs. So, in today's tech-driven world, AI is transforming the way business operates, innovates, and connects with consumers. People are transforming their to Ghibli style or asking ChatGPT to draft social media content. We are relying too much on AI even today, as and future who knows what will be. As AI generated content becomes more common, it raises important questions about IP rights. Who owns the work created by the AI? Can these works be legally protected? How do we prevent AI from unintentionally copying existing work? These are the issues that are the heart of the discussion about AI and IP law today. So I will be speaking on the evolving relationship between AI and IP, the legal challenges it presents, and the possible solutions that businesses, corporate houses must consider in an increasingly AI-driven world. So since I'm working as a corporate lawyer in advising business entities, so I'll be morely discussing on the issues that are faced and how, to some extent we can uh, manage that. So under a Copyright Act, the definition of author is provided. So author is the first owner of the copyright as per the Act. The Act provides that an author refers to in relation to any literary or dramatic work, the author of the work, in relation to musical work, the composer of the music, in relation to any artistic work other than a photograph, the artist itself. However, in case of an AI generated work, it is the AI itself that performs the task of the aforementioned categories of persons who are recognized as authors. So there's no individual or person which is involved. There's an artificial intelligence which is there. So therefore, the aforementioned definition of the author cannot be applicable in case of an AI generated work. Uh, on one argument, it can be said that AI generated work can be recognized as computer generated work in the present scenario. In this context, the definition of author under Section 2D6 of the Act is relevant, which provides that an author in relation to any computer generated literary, dramatic, musical, or artistic work is the person who causes the work to be created. Therefore, such a person who causes the creation of computer generated work is recognized as an author. So there are several persons who are involved in creation of the work. So I will be discussing on who can be classified as an author in case of an AI, and who can be regarded as a creator of the computer generated work. However, on the plain perusal of the provision, some people also counter argue that section does not take into consideration any computer machine which is intelligent to act as humans. So earlier the definition was included to only consider those computers which are operated by human agency or some amount of at least human interaction. So we are working on the computer, suppose in Microsoft Paint, we are creating a picture. So that's a creation which we are doing on the computer. So that may be regarded to be included in the definition, but not an AI generated content. So there are several potential models for assigning ownership of AI generated content, which have emerged. Each has its own implications and challenges. So there are five based broad models which I will be discussing today. Uh, Regarding the ownership by AI system, the system itself. So the under the current legal frameworks, ownership is typically tied to keep given to a legal person, which AI system is not. Therefore, this model approach is something which requires changes in the law if we are considering it. Granting legal personhood to AI would require a fundamental shift in the law, in fact, raising questions about who will be accountable and liable. for the same. Then the next model is ownership by AI developer. Given that the role of the developer in designing the algorithm and training the system, some people also argue that he should be granted the IP rights over the AI generated content. However, this approach can be problematic in cases where users provide specific inputs or use the AI in creative ways that may significantly influence the output. In fact, the terms of use for most commonly used AIs does not claim copyright over the outcomes generated. So I was going through the terms of use of some of the most commonly used AIs like ChatGPT and Deep AI. What I see was ChatGPT's terms of use assigns to the users all the rights, title, and interest in the generated content to the extent permitted by applicable law. In fact, Deep AI also, in the terms of service, provides that all content generated by its tools and APIs are free of copyright, and users may use them for any legal purpose, including commercial use. So, since with the ownership will come the liability, so I think most of the AI developer or the tools are not ready to take that. So that's the reason why they are disclaiming the rights as well. Next comes the ownership by user. So, in case of users' ownership, also there are disputes which may arise over the degree of human contribution required to establish ownership. So, in case there are specific inputs which have been provided by two users, so similar content may be generated. So, that's a question which may be raised. So, uh, given that, what are the specific inputs you have given because of which the content was generated? So, there are a lot of complexities which are involved. Next is joint ownership by the user as well as the developer. This may again lead to complications in practice because there may be disagreements between them over how to exploit the content generated, and of course the monetization of the content. Next, the last one that I have addressed is no ownership. So, treating AI generated contents as public domain material, since they are already emerging from the inputs which have been provided by the developer to them. However, this approach again has problems uh, of assign since if we are not assigning in a particular ownership, it may discourage investment in AI technologies and of course creative endeavors. So no one will want to engage in AI if they're not getting any benefit of IP rights. So no one wants to work for free basically. So apart from that, I saw that there are some other problems also which are there with the IP contents, AI contents. So the challenge is requirement of originality under Section 13 of the Copyright Act. So when we consider that, let us discuss a case law. I've been reading about a U.S. Copyright Office in September 2022. They made history by granting the first known registration of a work produced with the help of text to image generator Midjourney. So they generated a graphic novel called Zaira of the Dawn. So it's a landmark ruling. You can look into it online. Just a few months later, after the grant of the Copyright Office again reconsidered its decision, partially cancelling the work of copyright registration, claiming that it had non-human authorship. So basically, they said that while filing of the application, the person did not mention that it was an AI-generated content or it had some involvement of AI. So the book's text, as well as the selection, coordination, and arrangement of the written and visual elements remained protected. However, the image generated themselves did not get any protection because that was generated through AI. Interesting case, right? The office also deemed whatever editing was done to the images were too minor and imperceptible to supply the necessary creativity for copyright protection. So, creativity, something, originality, something which is also important in India. So, this is an important case law which might be regarded as precedent in India. Later, the US Copyright Office also released a policy change to address all AI human creative collaborations moving forward, a response to what it sees as new trend in registration activity. It states that if a human simply types in a prompt and a machine generates complex written, visual, or musical works in response, the traditional elements of authorship have been executed by an AI, which is a non-human. Therefore, it is not protected by copyright. The policy statement further stipulated that a work containing AI-generated material may be granted copyright if it contains sufficient human authorship to meet the standard required for copyright protection. So, I mean, this is only one legal issue which is there. There are more complex issues. As we all are aware, AI tools have been trained on massive data available on the internet, including articles, books, newspapers, social media posts, and other public web pages. So, ChatGPT has been trained on massive internet data available till 2021 and generates response by using and restructuring the data which it has been trained upon. Also, Deep AI similarly has been trained upon on a large amount of diverse text data from internet, allowing it to learn a broad understanding of language and effectively responding to a wide range of user queries. So, in different languages, multiple languages. AI's reliance on large data set raises ethical concerns about copyright infringement because they are getting trained on someone else's copyright or data. As AI generated works may unknowingly incorporate protected material without seeking prior consent. The question of liability, whether it falls on the AI developer, user, or copyright owner, remains unresolved. For instance, in the New York Times in 2023, I was reading an article. They sued OpenAI and Microsoft for using New York Times articles to train AI models. So there was a litigation which happened. US Copyright Office concluded in May 2025, which is very recently, that AI developers who use copyrighted works to train models that generate express expressive content that competes with original works who are original works going beyond the scope of fair use doctrine. So if they're training models and it's generating similar copyrighted work, then it's not falling under the exception of copyright law, which is fair doctrine law. According to the report, fair use does not apply when outputs close by resemble and compete with original works in their existing markets. To address this later, AI Act 2025 was launched in the European Union, which mandates generative AI tools to disclose copyrighted materials that have been used to develop them. Further, it provides for the right of the creators to opt out of the use of their creations in the training of data sets. So this is how globally the response is coming up. Apart from the Copyright Act, I think that the AI may also infringe upon the Trademark Act to a certain extent, because people may ask AI to generate logos for them, or in case there are certain documents which they are seeking to work upon, it has certain logo of a certain company, so that may also be a trademark infringement. So AI systems can unintentionally create names or logos that closely resemble existing trademarks, which increases the risk of brand dilution and consumer confusion. Further, since AI generated trademarks are derived from pre existing data, their distinctiveness also comes into question, potentially making them ineligible for registration. uh, Getting into an example, I was just going through one case law where users were using Microsoft Bing AI imaging tool to create images of pets in a Pixar style. So similar to Ghibli style image, while the intent was harmless, AI inadvertently generated Disney Pixar logo. Since Disney is also associated with Pixar, so those logos were generated with the images which was generated by the AI. Potentially, it was a case of trademark infringement. Walnut Disney Company intervened, requested Microsoft to prevent its AI tool from generating content that infringes Disney's trademarks. Microsoft later blocked the term Disney from its image generator, but that's not an solution, right? Because it's only one infringement from for Disney, but there may be other similar, infringements which may happen. So blocking Disney term will not be help. So to mitigate trademark conflicts, businesses use AI generated mark must conduct thorough trademark search before filing for registration. So, as a business entity, corporate house, the lawyers working there, they have major responsibilities. So AI is about AI, there has been much talk going about in WIPO conferences, India's parliamentary discussions, and several organizations such as Niti Aayog have also shared reports, articles on the topic, which is publicly available. The participants can refer to the same for more interesting perspectives as to what is to be done to ensure we use AI without any potential breach. There are some points, 3 or 4, that I have personally prepared. WIPO has released an indicative checklist which says, first things first, create internal policy or guidelines on usage of AI content to know how are we using it, what will we do in case there is a breach, how to ensure that there is no breach. Review terms and conditions on the AI tools before using them. And as a lawyer, some clauses which I will look out for when I'm viewing the terms is, who owns the IP rights? How is the provider storing your prompts? So in case you're giving some inputs, how is this prompts stored by the provider? Is there an indemnity clause in case there is an infringement? Who will indemnify whom? What is the liability? What is the amount? Is there any cap on the indemnity? How will the confidential information be treated? In case we are sharing inputs which are confidential for the company, how are those being treated? So those are certain things which are important. And lastly, the person using the AI tool in the organization should label or mark the contents which were generated through AI and keep a separate record of the same. So, understand, if in case there is an infringement in future, or there is any case or litigation or dispute, we are able to understand that, yeah, this was created through AI, and how can we protect ourselves or defend ourselves in such lawsuits. So that's all from my side. Over to you, Mr. Bose.